Hi, I'm Kate McBride with Fiduciary Wise. We know that managing retirement plans comes with a lot of responsibility, and having the right knowledge is crucial to making the best decisions for your plan and participants. That's why at Fiduciary Wise, we don't just provide fiduciary services, we're committed to educating those who manage retirement plans through resources like the Fiduciary Wise Brief. Our program delivers expert insights to help you navigate the complexities of ERISA, compliance, and the fiduciary risk management. If you're finding value in what you're hearing in this podcast and want to take your understanding to the next level, let's continue the conversation. Reach out to us at fiduciarywise.com/scheduling and learn how we can support you with the knowledge and tools you need to confidently manage your plans. Welcome to the Wise Fiduciary Podcast. I'm Kate McBride, one of your hosts from Fiduciary Wise. Whether you're a thought leader, service provider, CEO, or decision maker, this podcast is for you. We break down the best practices, the services and solutions available to you, and discuss the latest topics. Join us as we explore, challenge, and navigate the future of fiduciary responsibility together. On April 17th, the Supreme Court released what is being thought of as an earthquake of a ruling on a 401k lawsuit brought by the plan participants in Cornell University's retirement plan. This appears to be a very meaningful opinion by the Supreme Court. Our guest today is James W. Watkins III, a good friend of Fiduciary Wise, and I am happy to say a friend of mine as well. He is a JD, an attorney, a CFP Board Emeritus, and an AWMA. He's also the managing member and CEO of InvestSense and a Fiduciary Risk Management Risk Council. Congress enacted ERISA to protect the interests of participants in employee benefit plans and their beneficiaries. This is a quote from the law ERISA, and we're going to talk a little bit about that with Jim today. So Jim, what did you think when this ruling came out in terms of how it makes change for plan sponsors?
I thought it was a decision that was well overdue, simply because it helped clarify let me make an open disclosure. I am by nature a plaintiff's attorney, but I like to think I can be objective. So this was a case, we had never had a case which had thrust the burden of proof on the defendants in an ERISA case. This was the first one, and the court basically told plan sponsors that because PTEs are affirmative defenses, it's your burden to prove that the PTE applies to you.
Let's talk about what a PTE is, Jim, for any plan sponsors or anyone watching that may not know what it is. Can you elaborate a little bit on that?
PTE stands for Prohibited Transaction Exemption. ERISA sets out certain acts that are prohibited, and primarily those acts are acts which would compromise the best interest of the plan participants, or if there's a conflict of interest on the part of a person trying to sell a product or a service to the plan. So if you fall into that area, and anytime you're trying to sell a product, these always come into play. There's the conflict obviously being this person stands to receive compensation. So if you're engaged in a prohibited transaction, you need to find an exemption that will allow you to receive those funds.
Those are all together in ERISA. In other words, when I say together, not on the same page, but there is what happens if you break a rule, and then this is how you fix that, basically. Sort of a, hand in hand. Here's the rule. If you do this, you've broken it. And here on the other side is the remedy for that. These are the things you need to do to not be guilty of it. Is that
yeah?
An adequate way?
I like your first part better than your last part.
Okay. How would you do it? How would you say it?
I would say, well, let's go back. there are two sections, and this was a critical element in Cunningham. The court pointed out that the prohibited transactions are set out in a separate area of ERISA. So that's 406. 408 sets out the exemptions. And what the court said was because they are set out in two separate sections, they're not the same thing. And therefore, the court said, as a result, if you've engaged in prohibited transactions and you want to try to do the exemptions to protect yourself or clear yourself, get out of jail card, then that's under the law. And this is true of anything. Under the law, if you're going to assert an affirmative defense, that's your burden of proof. And so that's why this was so important. They are now saying it's not the plan participant's responsibility, it's your responsibility. And in most cases, it's hard to meet the conditions that the exemptions set up.
Part of this is because ERISA explicitly says that that an employer running a plan, a 401k plan, must run that plan exclusively in the interest of plan participants and beneficiaries. In other words, that is the most prominent part of running a plan. It has to be run for those participants and beneficiaries. It's not something that you can be casual about. As a plan sponsor, you really have to make sure that everything that is done in the plan is exclusively done for those plan participants. Is that really why so many of these lawsuits are brought, like Cunningham versus Cornell?
Well, in a situation where the cost is the issue, remember what the Department of Labor and the General Accountability Office said. Each 1% in fees over a 20-year period reduces an investor's in return by 17%. So a lot of these products have fees that may be 2, 3%. 3% times 17, that means that the investor, the plan participant, stands to lose 51% of their returns. So yes, that's exactly why you can't just look at what the product vendors say. Disclosure of these costs is so important.
Yes, that is so important. And the costs really are one of the things that really show up in these lawsuits so much of the time, because it's one of the canaries in the coal mine, if you will, that a participant can see if they're paying attention to their plan. And so when costs are out of line, they get upset because they are losing money, the money that they're going to need in their retirement.
And Kate, I think the other thing there, I mean, you're absolutely right, but I think the other thing is that quite often in these fee cases or unnecessary or excessive fee cases, the claim is made that insufficient disclosure was made. So the plan participants can't make the informed decision that 404C of ERISA requires. So it's not just that the fees are excessive, it's that you're not giving, when you ask a plan participant to choose an investment, they're not being told about the impact of these fees. And remember that under ERISA, there is no requirement that the plan sponsor provide any sort of investment education classes.
So what are some of the things that you, doing what you do as an expert witness, as an ERISA expert, as an attorney, what can plan sponsors do to try to have a better plan that won't have this fate of being sued? How do you mitigate that in terms of having a plan?
Well, I think
Participants.
I think the first thing is to understand what the laws are. You and I are both fans of the Restatement of Trust Third. And it's amazing to me how many times when I go out to meet a potential client, one of the first questions I ask them is, have you ever read the restatement? And they give you the deer in the headlights look. And it's like, I kid you up, there it is. There it is.
With all the Post-its, and
With the
placeholders.
multicolor stickers.
It's one of those things that Jim and Don Jones of our firm, Fiduciary Wise, have talked about for so long, and I'm not a lawyer. I should say that right off the bat, not even close. But this is such a common sense written book that you can look at the relevant areas of this book and really understand, and it's put in very plain language, that if you have a trust or if you are running a plan, that everything you do has to be in the very best interest of the plan participants or that beneficiary of that 401k or trust. That's the end of it. I mean, it's the beginning, middle, and end, really. And if that doesn't happen, then lawsuits like this happen.
Well, and Kate, remember what a lot of the courts have said. The courts have consistently pointed out that ERISA is essentially the codification of the restatement of common law. Yeah. So it goes back to what you just said. If you want to understand ERISA, look to the restatement.
Yeah, I've heard people say that the ERISA is sort of outlines what has to happen, but the Restatement of Trusts tells you how you do that. Because ERISA itself doesn't say how to do it; they just say you have to do it. But the Restatement of Trust will actually go through and say this is what you do, which is why these books are valuable if you're a serious ERISA person or a plan sponsor, or if you need to know what you need to know. You talked about reading the restatements. What are some of the other things that plan sponsors can do to learn what they need to know or to shift what they need to know to prudent experts?
Well, I think, in my opinion, the two easiest things to do, even though it's a self-serving statement, is retain the services of a knowledgeable and experienced ERISA attorney. From a practical aspect of administration, I am currently recommending to more and more of my clients to consider a 402 administrator. There's so much volatility right now in this area. At a minimum, talk to a 402A administrator. Let them explain what services they can provide. Because if you want peace to sleep at night, a 402A assumes all responsibility for the plan's administration. It does not relieve the fiduciary of fiduciary duties, but all they have, if they retain a 402 administrator, they just have to monitor what they do and simply go, okay, why did you do this? And if they can't explain it, then that should put you on notice of a red flag.
So the 402A named fiduciary is one of the roles that we have here at Fiduciary Wise as a firm. And it is something that a lot of plan sponsors and a lot of people that work in ERISA had never heard of before talking to someone like you or a firm like ours. But what does that mean, having a 402, administer and manage your plan? What is it? I would imagine, and I have not checked this, and you probably know this right off the top of your head, that there are not a lot or maybe not any lawsuits against a 402A named fiduciary firm. Is that right? Or a plan that has a 402A. I mean, I don't know this, but
I think as far as risk management in that perspective, I think that's clearly a question, and you research ahead of actually hiring the 402.
Mm-hmm.
There are all kind of legal resources like Westlaw that you could look up if they've ever been a part of a lawsuit. But whether or not, I'm not saying it's not important, but I think the important point from the perspective of a plan sponsor, at least to initially consider talking to a 402, there can be no argument that retaining a responsible and experienced 402 reduces the risk of liability exposure.
Yes, I think you're right there for sure. It's one of those things that Don Jones talks about. The first ERISA 401 is that you have to have a plan document. ERISA 402 is that every plan has to have a 402A named fiduciary, and usually that's the plan sponsor now. But going back, we understand that in the beginning, when ERISA was first brought out, there weren't 401ks, but as the shift when 401ks came out, shifted to 401ks instead of pension plans, that the plan sponsor, who didn't used to have to run the pension plan, they just hired people to run it for them, weren't really supposed to be running the 401k. The plan sponsor was never supposed to be the 402A named fiduciary on the plan. And that evolution from not having to do that, hiring prudent experts to do it, to most employers that have a 401k, they run the plan. It's an interesting shift, and I think it surprised me the first time I learned this, long ago, and I think it's surprising to most people. When we talk to lots of folks in the industry, they don't know that there needs to be a 402A named fiduciary on every plan, and that it wasn't supposed to be the plan sponsor.
Yeah. But one of the things I point out, a lot of people say, well, that's just an added expense. I think one of the immediate benefits that a 402 fiduciary or a fiduciary attorney can provide is helping you draft an IPS, investment policy statement. One of the most common mistakes I see is including things in IPSs that shouldn't be there. And what I mean by that is if you get involved in litigation, a good attorney is going to take that, and also the Department of Labor is going to take the IPS and compare what you actually did in the plan, what practices you followed with what you said in the IPS. And if they don't match, it's not a good situation for the plan sponsor.
I think that is one of the most important things I've ever heard anybody say about ERISA. Jim, let's go back to Cunningham versus Cornell University and talk about some of the impacts that you're seeing from this ruling from the Supreme Court of the United States, this earth-shaking opinion that came out last week. What are you hearing about from your clients or folks that you're talking with about the impact of this, and what can plan sponsors do to help to protect themselves and their plan participants?
Well, as far as protecting themselves, I know they don't like costs. I think now would be a good time to consider a fiduciary audit. The important thing is every aspect of the plan needs to be reviewed, because what Cunningham said is that if questions arise as to your plan, you're going to have the burden of proof. So what we're seeing and are going to see in Cunningham, I think everybody's predicted we're going to see an increase in litigation against plan sponsors. I think that's true. As an attorney, I think a question is going to be plans that had legal action under ERISA and the courts dismissed their actions because they tried to put the burden of proof on the participants who didn't have the necessary information.
Mm-hmm.
I think attorneys are going to have to go back, or I think they have a legal duty to go back and ask the court that ruled against them and dismissed their case to reconsider their ruling in light of Cunningham. And from talking to a lot of attorneys, they are discussing that as to whether or not the plan wants to do that. And along those same lines, if you're a plan sponsor after Cunningham, and if you do not at least ask the court, given the importance of this ruling, to reconsider, there's a question, or at least in my mind, there's a question as whether the plan participants can claim a breach of fiduciary duty for not pursuing recovery of that possible money. So I think we're going to see the litigation. I think a lot of attorneys are going to have to go back, reconsider what they did. And the other thing is they need to talk to an experienced legal counsel, because this is complicated. I think we're going to see more cases shifting the burden of proof on them. So now's a good time to figure out, okay, if that burden were thrust on us, could we meet that burden? And I'm on record. I don't think they're going to be able to meet that record either with regard to mutual funds and certainly not annuities. So they're leaving themselves exposed to unnecessary liability exposure.
Can you talk about what burden shifting actually is and how it works?
I guess the easiest way would be to compare in litigation. In typical litigation, the plaintiff has to prove all aspects of their case. And that's what the defendants, the plan sponsors, have been arguing in this situation. But the problem with that, with regard to ERISA litigation, is that more often than not, the plan participants don't know what the plan investment committee or the plan as a whole, what they did when they made their decisions. And sadly enough, a lot of courts have ruled they don't have to tell you. And that's absurd. So what we've really got here is with Cunningham, if, as some of the judges recommended, a trial strategy that they might use, the courts have, if the courts are not going to shift the burden of proof, then they have to allow discovery. And as you and I were discussing earlier, that's going to be a key issue here. And the Supreme Court has already argued in 2 cases that they're going to look at further instances of shifting the burden of proof. And for technical reasons, I just don't think plans are going to be able to carry that burden of proof to get the protection offered by prohibited transaction exemptions. So they need to address that and do whatever is necessary to reduce that liability exposure.
How different is this case from so many of the other cases that we've seen in the last, it's something like, is it at least 500 cases since 2016 or so, something like that?
It's a lot.
Yeah.
The late Justice Ginsburg made a comment that the Supreme Court typically does not like to hear ERISA cases. ERISA law is complex, and a lot of people just aren't familiar with investments. So if the issue is commensurate return relative to alleged excessive cost, they're just not prepared to analyze that. So this was an atypical case in that it involved issues of clear wrongdoing. So it was easier for the court to apply here. And to be honest with you, we talked about the restatement earlier. The restatement, there's a section of the restatement, section 100, that says that if the plaintiffs established that a breach occurred, then the burden of proof shifts to the plan sponsor. The problem is we've got too many of the federal courts that have ignored the restatement. So that was a key issue here. We were talking earlier, I think they need to go further, but this was the first instance where, and the court did reference the restatement for saying the burden shifts. I mean, this wasn't a complicated case. Back in the Tibble case, the Supreme Court ruled in fiduciary cases, look to the restatement. And that's exactly what the Supreme Court did in Cunningham. It looked at what I just referenced, Section 100.
So this is where our Restatement of Trusts third comes in, Section 100 of this book. We're not hawking the book. We just use it. So
We don't get any profits from it, but the point here is that it's there. And as soon as the case came down, I had several friends text and email me. The decision of the court shouldn't surprise anybody that's familiar with the restatement. The fact that it was 9-0,
yes,
a unanimous decision, I don't think anyone would have predicted the Supreme Court to have been unanimous.
How earth-shaking is that part of this case, Cunningham versus Cornell, that it was a clear 9-0 Supreme Court vote in favor of the plan participants, basically?
Well, if you know anything about the current Supreme Court, Justice Thomas and Justice Alito don't often vote for the public. And they definitely, in their decisions, have favored big business, especially the financial services industry. But Kate, if you look in the concurring opinion, it was interesting that what I thought might have prevented a 9-0 vote, the justices argued that the decision was going to result in a lot more litigation and a lot more costs. My response to that, to people that have contacted me, is Justice Kavanaugh made that point during the oral arguments. And it was quickly pointed out to him that judges have ways to control those costs. Judges have a way to prevent unnecessary litigation. And so my response to people has been, as a former trial attorney, judges can do what's called limited discovery, or they can do what's called controlled discovery. And what that means is that the plaintiffs, the three judges that issued the concurring opinion, that point, in my opinion, is just a red herring. It's just not true. So the judges have these powers. If they don't use them, that's not the plan participants' fault. And I thought that was interesting that Justice Sotomayor pointed out that may be a legitimate concern, but it doesn't overweigh the ERISA's concern for the plan participants. And she was absolutely right.
It's so interesting. Justice Sotomayor wrote the opinion, correct?
Correct. The majority opinion.
The majority opinion, and thank you. And in one of the lines in it said, ERISA is an orthodox format, black letter law. Read what's in the law and apply it. So how do plan sponsors do that?
You need to go back to our Bible, the restatement. If you open up the restatement, the restatement is a restatement of the English common law.
Yeah.
And so when you look at the restatement, each principle is set out in heavy, bold, black type. That's what they mean, black letter of the law.
Black letter law, okay.
Because it's emphasized. And then the rest of the restatement typically contains comments espousing on other aspects of the law and really fleshing it out, helping you to understand what that black letter law means.
What else did you find different about this ruling, and how do you think that it may affect lawsuits going forward in terms of lawsuits on plans for the same kind of overly expensive investment options or record keeping that is overcharging? At least these are some of the allegations. I shouldn't say whether these things are true or not, but this is what a lot of the suits say.
Well, again, as a plaintiff's attorney, in most of these cases, the plan sponsor has the information. So I can point out how a mutual fund in the plan may be cost inefficient relative to an index fund, for instance.
Mm-hmm.
But some of these courts were demanding more detailed information. So one of the things I liked about the decision was it basically says the plaintiff still has a responsibility of presenting a plausible case vis-a-vis the issue of did a breach occur.
Mm-hmm.
But once that happens, then the burden shifts. And I think that's fundamentally fair because a lot of these courts have been refusing to allow or to demand that the plan sponsor provide them with sufficient information to make their case. With annuities, I can do a break-even analysis and show how the annuity, based on betting, the annuity favors the insurance company issuing it, and that the odds of the plan participant receiving commensurate return, which is in Section 100F of the restatement, it's not fair to a plan participant if the odds of them not receiving a commensurate return if it favors the plan sponsor. So now we're going to hopefully get away from that ruse. If I come in and I make a plausible case as to the fact that a breach occurred, then the burden shifts to the plan sponsor. And I'm on record, I don't think they're going to be able to carry the burden of proof in many cases because a lot of these investments, be they cost inefficient mutual funds or annuities, they're not in the best interest of the plan participants. That explains why the financial services industry has fought so hard against a true fiduciary standard.
So what are the things, do you have in mind, we've taken so much of your time, and thank you for so much of your time that we've been able
my
to
pleasure.
talk about this. We've spent a lot of time together, you and I, on the phone, on email, at the DOL. I always learn more every time I hear you speak or read something that you've done. What are the things that you would say, maybe if you had a top 3 things? We started at the opening with, a few things that plan sponsors can do that help make their plan better on behalf of the plan participants, which is what ERISA requires. Plan sponsors must always manage the plan solely in the interest of plan participants. So we've gone through a lot of this here, but can you wrap Cornell, the Cunningham versus Cornell, can you wrap the Cunningham versus Cornell case around 2 or 3 things that would help the plan participants have a better retirement?
Well, obviously, the obvious answer there is ERISA does not require investment education. But I'll tell you a quick little story. I was at a conference one time, I gave a presentation, and I was standing in line for lunch, and the gentleman introduced me as the firm's CEO. And he told me he appreciated the presentation, but he goes, "We're never going to voluntarily offer investment education to our plan participants." He goes, "They would call somebody like you and then we'd get sued." And at first I was angry, and then I thought about it. He's right. But if you really want to be fair to the plan participants, and a lot of litigation right now still isn't fair to them, we've got courts making different rulings on the same law, ERISA. And that's why I think we're going to see increased activity. Well, we already are seeing increased activity by the Supreme Court. I think you need to understand the product better. There are certain limits to what a plan sponsor can and cannot disclose. I think we just need to really focus on providing. When I talk to a plan, I've got some things that I use, quick little hacks, if you will. And I'm not saying you have to teach plan participants how to do complex calculations, but I think ERISA owes them at least enough information to put them on notice that they may need to contact somebody else. We don't do that right now. I think we're about to see more litigation. I think we're about to see more Supreme Court. Plan participants have not had an effective voice. Congress doesn't help them. And we're seeing more judges. I've been surprised at the judges who have stepped up and said, hey, this isn't right. And I think that's what, to me, the Cunningham case, bottom line in Cunningham was the Supreme Court stepping up and saying, this isn't right.
Mm-hmm.
This isn't consistent with ERISA. We're basically eviscerating ERISA. We're playing a game here. This is these people's lives, their financial security.
Absolutely.
We've got to do, if Congress won't do something, if the president won't do something, then it's our responsibility. And I think we're seeing that. And I think we're going to continue to see that.
I think you're so right, Jim. Are there any other cases coming down the pike that we should keep an eye out for, or just in general, have our Google search on ERISA cases?
Home Depot.
Okay.
The Supreme Court has already asked the Solicitor General of the Labor Department to issue or give them what's called an amicus brief. Amicus is short. Well, it translated, it means friend of the court. And as you and I have discussed earlier, I think it's really interesting that they're asking the Solicitor General to issue an amicus brief in Home Depot, primarily because while the case was pending in the 11th Circuit Court of Appeals, the Solicitor General did provide an amicus brief. So I'm fully expecting the amicus brief that the Supreme Court has just now requested to say the same thing. And in that case, in the amicus that the Solicitor General previous sent, he said the burden of proof has to shift to the plan sponsors. They're the ones with the information. So again, plan participants always have to make a plausible case that the breach occurred.
Mm-hmm.
But once they've done it with the limited information they have, the Solicitor General said the burden of proof, because of the asymmetry in information, the burden of proof by necessity, if we're going to be fair under ERISA, the burden of proof has to shift to the plan participants. And the plan participants go, no, we can't carry it. And I've talked to counsel for the financial services, and they go, we can't carry that burden. So that's what we're seeing now.
Wow. Well,
I think Home Depot, I believe, once the Solicitor General provides the new amicus, I believe that the Supreme Court is going to grant certiorari and hear the case. And I don't think the financial services industry is going to like the ruling.
Wow. Well, this is something that we have to watch out for. And I hope that you will have time to come back and talk with us again. It's always so much fun to talk with you. And I'm so privileged to get to talk to you so often over chat, over email, sometimes on the phone, sometimes this way. I feel like the luckiest person around. Thank you so much, James Watkins.
It's always a pleasure and a privilege.
Thanks for tuning into the Wise Fiduciary Podcast. We'd love to hear your thoughts and answer your questions. So drop us a comment, send us a message, or schedule a meeting with us at fiduciarywise.com/scheduling. And don't forget to join us next time for more insights and discussions. See you in the next episode. Thanks so much, Jim.
Hey, I'm Isaac Wood with Fiduciary Wise. With years of experience helping plan sponsors, TPAs, record keepers, and advisors navigate the complexities of retirement plans, I understand that every client has unique needs. That's why our MEP, PEP, and DC group of plan services offer complete customization. Whether you're managing multiple plans or looking to streamline administration, we tailor solutions that fit your goals while also ensuring compliance with ERISA regulations. At Fiduciary Wise, we don't just offer cookie cutter options. We work closely with you to design a plan that maximizes efficiency, minimizes risk, and gives you the control that you need. Imagine the confidence of knowing that you have an experienced team behind you, guiding you every step of the way. If you're ready to take your retirement plan to the next level, let's connect. You can schedule a meeting at fiduciarywise.com/scheduling to see how we can help.